Just as a reminder, the information that we're giving to you today is for information for you to learn. If you need to get further legal advice or professional financial advice, make sure that you speak to someone directly because everyone's situation is different. But we'll start now. Thank you very much for joining us today for the 2025 Elder Law Seminar. I appreciate you all coming today. My name is Joanne DiPietro. I'm an attorney in Walpole. I'm coming up on my 27th year of practicing law, and thank you. I have to say I love every minute of it, and you guys add to that as well. Today, Matt Antonellis is here. Matt came last year, if you remember, and Matt will give us some important financial information. Today, we're going to start with the documents, those documents that we always chat about. The important part of why we're here today is to remember that you want to be heard. That's what all of this is about. There's a little on the handout down below. If you want your goals to be met, an estate plan is essential. What does it mean to be heard? It means to make sure your goals, your wishes, your desires, everything that you want to happen, whether it's $5 or $5 million, where it needs to go, if it's a piece of jewelry that's 25 cents that you got in a bubblegum machine or your 3-carat diamond ring, wherever those items, whether financially or sentimental, where they're going to go, you need to put it in writing. You have to have it in writing. If you have specific wishes, you need to put those in writing, because if you become incapacitated, you lose your marbles, or if there's a death, no one's going to be able to know what you wanted. And in those particular times, we need to remember that we're all human, and death and grief kind of make us do kooky things sometimes. And you want to make sure that everyone understands what you wanted, and you can't just verbalize it, because sometimes people can hear things a different way, and the last thing that you want is your family getting argumentative as to what your wishes were. So putting everything in writing is important. A lot of you, we've worked together or we've spoken about it, and there's also a lot of you that say, I need to get in touch, whether it's me or with your own attorney, to make sure that you've updated documents or even drafted documents. And the documents are the key. If you look in the handout in the top left-hand corner, we have essential documents: the healthcare proxy, the power of attorney, last will and testament, trust agreements, and a homestead. Let's talk about the will for a second. The will is the foundation of your estate plan. You have to have a will. You can't say, I have a trust, I don't need a will. You have to have a will. Why? Because the will is the document where you state who your personal representative is going to be, formerly called your executor or your executrix. You might be more familiar with that term. It's now called a personal representative, which I kind of like anyway, because it is. You're the person and you're representing the decedent. Once you're deceased, we're in like this little purgatory world. No one can speak for you. You can't speak anymore. And someone needs to be appointed, and the person to be appointed would be your personal representative. Your personal representative marshals all the assets of your estate, make sure all the bills are paid, make sure anything that needs to be tended to, whether it's your funeral or medical things that need to be tended to post-death, are taken care of. Then their job is to make sure that the beneficiaries get what they're supposed to get. So the items that the personal representative is dealing with are two. You have tangibles and you have intangibles. The tangible things are everything you can see, feel, and touch. Your furniture, your baseball card collection, your jewelry, your Mustang from 1968, whatever it might be, right? Everybody laughed at the Mustang, but where's the Mustang going? If you don't write down who's going to get it, we're not going to know. Those are your tangible items. Your intangible items is your house. Yes, you can touch your house, but you can't pick your house up and leave it and take it and put it somewhere else. Your bank accounts, everything that Matt will help you with your finances and your investment, that's intangible. You can't touch those things and take them. So all of those need to have a place to go. What do we talk about when we say a place to go? When we own assets individually, those assets become probate assets upon our date of death. Why? Because they have nowhere to go. A lot of you may own your homes, spouses, husband and wife, tenants by the entirety. That gives you the rights of survivorship. Rights of survivorship says, my 1/2 undivided interest in my home in Walpole will immediately go to my husband upon my date of death, because there's rights of survivorship. Upon my death, if I own it individually, it has nowhere to go, except for probate court. And probate court's not a bad thing. It's just we have to use the probate laws in order to take my home and pass through probate and make sure it gets to my appropriate heirs at law, okay? So one of our goals that we want to try to accomplish is to avoid probate. We want to either have an ownership that avoids probate, or we want to make sure that we have it in a trust. So that's my segue into a trust. We've already talked about having a will. We want to have a trust. And if you've attended my sessions previously, the common trust that we use is that revocable trust. The revocable trust that has, think of it, a 2-layer system. This is the document. This is the trust document. This underneath layer is the second layer. That's the equitable interest in the trust. During your lifetime, you are the trustees of the trust. You and your spouse, or you and your child, or you alone. You're the trustee of the trust while you have marbles, while you have capacity, and while you are alive. You have the right and the powers within the 4 corners of this document of this trust to take care of all the assets that are in the trust, okay? You didn't lose dominion and control over it, the assets. You can still use those assets as you wish. If it's a house, you can put a mortgage on it. You can rent it, you can sell it, you can do anything you want with it. The good part of using a revocable trust is it avoids probate. You've changed the ownership on your property to your revocable trust. So now the trustee is the representative of the assets of the beneficiaries. They're the ones that can take care of things, whether you lose your capacity or upon death. That gives us the opportunity to stay out of probate court. Probate court's time and money. Probate court gives us the laws of intestacy if you die without a will, but we want to make sure we have a plan put together so that you can be heard. Let's talk about fiduciaries for a quick second. A fiduciary is a person that you appoint to speak for you, again, upon death or incapacity. We've already talked about the personal representative as a fiduciary. A fiduciary has a very high standard under the law, even higher than a parent-child. So that fiduciary within your trust that you've appointed is called your trustee. If that trustee absconses with your money, means takes the money and uses it in a fraudulent manner or a negligent manner also, that's actually a criminal action that they've done that. So you can see when we start talking about all of these fiduciaries, you need to pick people that you know that you can trust. You need to pick people that you know that can take care of these items for you. We don't have a crystal ball. We don't know when something's going to happen. We don't know if something's going to happen. So that's why I love seeing you here, because then you're starting to think about preparing. Estate planning is just preparing for something that's going to happen. So let's go back to that trust. That revocable trust is also going to tell us who the beneficiaries are. If my home is in that revocable trust, upon my death, it's going to say who is the beneficiary of that second layer, right? All of the assets. Where are those assets going to go? If by chance one of those beneficiaries is either incapacitated or under the age of 18, because we can't hand children under the age of 18 money or a house or cash, or why would we? Maybe we even want to wait until the age of 30, right? Depending upon how much it's going to be. This is where your document will be specialized to your particular life, your particular family matters. So we have a trust within a trust that also gives us the opportunity to hold money in trust for another person to either protect it from themselves or even protect it from other creditors, okay? The other portion of a revocable trust that comes into play is when we talk about estate taxes, okay? So I'm just going to smidgen this a little bit. Maybe when we get to the questions, if there's more questions, I can elaborate more. But you know the adage, you pay taxes when you're dead. I'm sorry, when you're alive, you pay income taxes, and then you pay taxes when you're dead, and those are called estate taxes. So we want to try to avoid estate taxes as best possible, because who wants to pay them twice? I don't. So within your revocable trust, we have an opportunity to put inside that trust what's called a special marital trust, an AB trust, a family marital trust. It's different names that you can use, but essentially it's sheltering. And sheltering means when you take an asset and you put it over there, you can't touch it, so creditors can't touch it, okay? When you can't touch it, that means we sit down and we make a determination as to whether or not you need that asset. You need that asset, you need the equity in that property to live on. You need the equity within that asset in order to take care of yourself later on, okay? So these are all, like I said at the beginning, these are all particular items that everybody has something different going on in here. I work with financial advisors directly so that we can determine as a team to make sure that we're appropriately placing our clients' assets into an appropriate trust for them. And again, we don't have a crystal ball, but we try to develop a plan that works for this year, 5 years, 10 years, 15 years down the line. So it's kind of like set it and forget it. You know, you can keep going. When do you have to look at it again? You look at it again. Usually life circumstances, life changes, somebody's born, somebody dies, you win the lottery, you file bankruptcy. Those are the types of things that you want to definitely revisit your estate plan. Let's go back to fiduciaries. If a fiduciary dies or becomes ill or all of a sudden has a terrible diagnosis, or you're just not talking to them anymore and you decide you want to change them, you can do that with these documents, but you need to make sure you do it before you lose your marbles, because you have to have the capacity for me to take your notary acknowledgement so that I know it's your free act and deed willingly and voluntarily. Okay? Any questions on that so far? Because you know I can talk about this stuff forever, so. Okay, yes. We're just going to use the microphones today because we are being recorded. Thank you.
What is the difference between the fiduciary and power of attorney?
Okay. Excellent question. The question is, what's the difference between the fiduciary and a power of attorney? The power of attorney is a document that we're going to speak about as well. The fiduciary is the person that you appoint to speak for you with the powers in that document. So a fiduciary is an appointment of a person to speak for you. Under a will, a fiduciary is your personal representative. Under a trust, your fiduciary is a trustee. Under the power of attorney, your fiduciary is the attorney in fact. So we can talk about a power of attorney right now. Power of attorney is when you're alive and you have given someone, I'm going to give you the power of attorney over me, my assets. She can slip into my shoes and go to Walpole Cooperative Bank and make a bank transaction for me if she needs to. We talk about original documents. Remember, don't ever give away your original documents. Always keep them. You can show it to them. You show them the original. You pull it back. Let them make a copy. Or you make some copies and you bring them with you. So when you have a power of attorney, you're giving someone else the right to slip into your shoes to speak for you. Make sense? The other document, when we're alive, that we have people speak for us is a healthcare proxy. This is really important because healthcare proxies, not only do you have a healthcare proxy that says my spouse can speak for me with respect to any medical directives or medical procedures, but there's other particular things rather, that some people may or may not want. And that's important that that's expressed to your healthcare agent. That's a healthcare agent is your fiduciary under a healthcare proxy. The principal, when you hear the word principal, it's usually the person that's signing it. It's my healthcare proxy, and I'm appointing Matt as my healthcare agent to speak for me. I'm the principal. But there may be some particular things that I don't want. And one of the things you may have heard of is called a living will declaration. And the living will declaration is somewhat of a misnomer because in my eyes, and I'm not a medical person, but in my eyes, you're not really living. This is if you need to be kept so-called alive with extraordinary measures, machines. And if you do not wish to be kept alive with extraordinary measures, you need to tell your healthcare agent, because your healthcare agent has a really big job. If you are in a car accident and they rush you to BI and Needham, and they put you on machines to make sure all of your organs are getting all the blood that they're supposed to, but then they figure out that your brain's not working. The engine's not working, so how's the car going to run? So if your healthcare agent knows that you have a living will declaration and you do not wish to be on those extraordinary measures, your loved ones or your friends, your family, whoever it is, need to know that, and that person needs to be supported well. And if there's any question of it, we have the healthcare proxy that was signed and witnessed by 2 people and notarized. And it says at the time of their signing, they knew what they were doing, they had their free act and deed, they weren't coerced, and they had capacity, which is being over the age of 18 and all their marbles. So it's very important to have these documents because you're not only protecting yourself, but you're protecting your fiduciary, the people that you appoint to speak for you, okay? Now, all these documents that we're talking about, something bad's happened, unfortunately, and we're all human. And like I said, our human characteristics, they pull up, and sometimes we can be unreasonable when we're sad or mad or angry or grieving. So another good reason to make sure that everything's in writing. Now, somebody may ask, because we're talking about elder law, a MOLST form, MOLST. I did write it out on this handout because everyone always asks me, and for some reason, I just can't get that. Medical orders for life-sustaining treatment, MOLST. It's the bright pink form, like that lovely lady's shirt right there. It's the bright pink form that patients fill out with their medical advisor, their primary care provider, their medical doctor in a hospital. And these are life-sustaining treatments. Do you wish to be kept alive if you needed CPR? Do you want to be resuscitated? Do you want to be intubated? Do you want a feeding tube? Those, I don't handle those. Those you handle with your primary provider. Usually if someone is at an older age or if someone has a diagnosis that, isn't so great. Those are important to have as well. Those forms usually get taped to the refrigerator. So if there's an emergency circumstance, everyone knows where to look. Okay, I don't know if anybody's had any experiences with those with their parents, but they're very important. And within it, it gives us our end of life choices. Do you choose to be, someone who is frail? Do you really want CPR? They could break your ribs. Those are the types of questions that or conversations rather, that you have not only with your doctor, but also with your family. Any other questions on those documents? Durable power of attorney or healthcare proxy? No? Okay. Let's go back to trusts, because some people are afraid of them, whether they had experience because someone, whether their parent or their grandparent, if there was a trust and the administration of the trust was a little bumpy. Trusts are good. Trusts are a good thing. Again, it keeps us out of probate court. It gives us the authority for someone to immediately step up. If Matt and his wife have a trust, a revocable trust, and I happen to be the successor trustee to it, And sorry, Matt, I always have the husband die first in my hypotheticals. Matt passes, and then Megan loses her marbles, and it gives me the opportunity to immediately step up. Okay, so we don't have to go to court and get me appointed. When we go back to the healthcare proxies and the durable powers of attorney, if you don't have those, we either have to go to court and have a guardian or a conservator appointed. Durable power of attorney, think of it as financial, buying, selling things, or stock market, or financial, or IRAs, dividends, all that kind of stuff an attorney, in fact, deals with. And if you don't have an effective durable power of attorney and you lose your marbles, we'll have to go to the probate court and have a conservator appointed. Conservator handles the money part of the person that's under the conservatorship. If you mentally can't take care of yourself and there isn't anyone to, you don't have a proper healthcare proxy, we may have to go and have a guardianship appointed. So as you can see the theme here, you have to have authority to speak for someone else. And if you don't have it within an effective, solid estate planning document, we end up in court. Which again, court's not a bad thing, but it's time and money. So let's spend the money now. Let's do the work now to make sure that everything is taken care of. Yes?
Can you have more than one durable person,
The question is, can you have two attorneys, in fact, acting together?
No, not attorneys, but the durable...
Durable power of attorney, that's what they're called, an attorney in fact. That's your fiduciary. So this is a great question. Thank you very much. Because people sometimes feel bad if they pick one child over the other. This is my view. My view is always you can do whatever you would like to do. However, if you have two attorney in facts, they have to work cohesively. They have to work together and they have to make the same decisions. Normally, the durable power of attorney and the healthcare proxy, I call them the Saturday night documents because they're really sometimes mostly used in an emergency circumstance. And if at that particular time one's either not available or they're in disagreement, then we're stalled. There's no referee, black and white t-shirts, information in these documents to settle a squabble. I prefer to see one person appointed, and then you can have the other person as a successor to them or something to that effect. That's my recommendation. Again, will I write one for you? Yes, I will. But again, these are used usually in circumstances where it's tight time. Anything else? Oh, thanks, Matt.
Hi, if you have these various people appointed, and presumably very often it's the same person in multiple roles, then why do you need the trust? If you've got your will, you've got your power of attorney, you've got your healthcare person,
Yep.
What does the trust add?
Great question. So the trust is the holder of your assets. You still own them, but we just changed the title. For instance, your home to the trust. We would sign a deed from you individually over to you as trustee of your trust. So upon your date of death, that asset doesn't go through probate. That's the first reason for a revocable trust. Second reason is if you do lose your marbles and the house is already in that trust, that trustee immediately steps up and can take care of everything right then and there. Anything else? And if you have questions for Matt now too, if you're starting to think of that, feel free. The other things that I just want to go over today is some of the questions. We've already done all that. These are more procedural type things. These are a lot of the questions that I've been getting recently. And I've probably said to you before, people just email me questions and I'm happy to answer them. Where do I keep my documents? It sounds like a silly question, but these are important documents that you've invested time and money in, and it's important to keep them in a safe place. I recommend a waterproof, fireproof safe. I think Amazon's the only place that we buy stuff now, so I know that they have one. But you also want to make sure your fiduciaries, the people that speak for you, know where those documents are. So if your safe has a code or a key, make sure they have that code or key. All right, you want to make sure that documents are easily accessible. That's always important to do. Really, the only other thing I want to talk about is updates. If you have updates to your documents and you're thinking about doing it, just make sure that you do it. A great time to assess your documents or assess your estate plan is when you're doing your taxes. Because if your assets have changed or you want to do some gifting or something like that, we're usually thinking about things like that when we're handling our taxes. There's a question down there. Thank you. So every year, or at least 3 years, I know every year is kind of crazy to think that we can do it every year, but it's a good idea to assess everything, make sure your beneficiaries on your financial institution accounts, make sure your beneficiaries are updated appropriately. If you have had a life change, someone has passed in your family, if they were a beneficiary, make sure whoever the alternate beneficiary is the person that you really want them to inherit that fund from. Yes.
This deals exactly with that. If someone has died and their name is on the deed to your home, how does one go about updating that, or is it necessary to do so?
Great question. That has like 3 prongs to it. Good question. So it depends on how you held title. If you held title with rights of survivorship, that person that you held title with, their undivided interest immediately goes to you upon their date of death by way of contract, because that's how you held the ownership. How to deal with it is to record their death certificate at the Registry of Deeds. Okay? Because that will show that upon their death, their undivided interest immediately went over to you. In the event you held title individually, 2 people holding it individually, meaning there's no right of survivorship, that's called tenancy in common. And what happens is those interests drop down through the laws of intestacy, okay? Because now we're leaving the contract of the deed, the 4 corners of that deed, and we have to get that 50% interest, we'll say is our hypothetical. We have to get that 50% interest to whoever that person, that decedent, either left in their will, left that 50% interest to, or by ways of the law of the intestacy. So the best way to hold real estate is with rights of survivorship. Joint tenancy, if it's spouses, we can say tenants by the entirety. That gives a little extra creditor protection. But that's why it's important too, when you buy a new home or whatever it might be, a second home, to make sure that the deed is properly titled. Any other questions on that? Yes.
What if you move from one state to another?
What if you move?
From New Jersey to Massachusetts?
And you're asking me if you need to update your estate plan? And my answer is yes. Thankfully, there's a uniform probate code. Massachusetts, they adopted the code in the earlier in the 2000s, which was nice. So we do have uniformity to not only our documents, but also to the probate process. But every state has their own laws. For instance, estate taxes. You know, our threshold is $2 million. I don't know what New Jersey is. But when someone comes to me and they have moved, I recommend that they start from scratch. Because first of all, you may have done it a long time ago and things could have changed. Yep. It's new. Yeah. 5 years ago. Well, you may have some updating, but, you can talk to an attorney. I'll tell you, I personally, I won't review documents from another state because I'm only licensed to practice law in Massachusetts. So I wouldn't be doing you any service or myself to review your documents from New Jersey.
Somebody that can handle that.
Well, you would need somebody that practices law in New Jersey to that are familiar with it.
I was going to call you, but now I'll have to find somebody else.
Well, honestly, I think you would probably hear the same from any other Massachusetts licensed attorney. Because don't forget, we want to make sure that everything flows nicely for you. And if there's items in those documents that could contradict Massachusetts law, then that'll be a problem. So, any other questions? Yes.
How often should you change or update your homestead?
You knew I was going to go to Homestead next, huh? So you don't have to change or update your homestead if it was properly claimed. Properly claimed means whoever the owners on the deed are, there are different statutory provisions that you claim a homestead. What's the definition of a homestead? A homestead is a document that gets filed at the Registry of Deeds, and it protects your equity interest in the property from an involuntary lien holder. A bank is a voluntary lien holder. You said, hi, I need to borrow $200,000. So you sign a mortgage. That's a lien holder, but it's voluntary. This is if you get into a car accident and unfortunately you hurt someone and they find you negligent and they get a judgment against you and they place that judgment against your house and try to sell your house to satisfy that debt, kind of like a foreclosure, sell the house to satisfy the debt. The homestead stops them from being able to do that, okay? Now, your homeowner's insurance defends your claim. They defend your claim. They have attorneys. You pay for attorneys to defend a claim. But the homestead stops them from being able to sell your house to satisfy the debt. And also, if you sell your property, the proceeds go in your pocket. It doesn't go to the creditor. Why would you have to update your homestead if you change title? If you change it from you and your husband individually to you and your husband as trustees of a trust, then we would claim the homestead under the trustee statutory law. Or if you're an elder in Massachusetts, which is only the age of 62, we also want to claim it under the elder statute, because under the elder statute, spouses together each get $500,000 worth of equity protection, which in total would be $1 million. So that's a good reason to update it. Okay? If you don't have any more questions, I think I'll pass it off. Yeah.
There was something on the news about people selling your house on you,
So,
online or something.
yeah.
And you,
so welcome
they
to the
come in,
world
they
of
claim
fraud,
your house,
right?
fraud.
Everywhere we are, we have to look. We have to make sure that we're protected, whether it's your computers, if you're using online banking, if you're using apps on your phone. So one of the scams that these people are so clever. I wish they would use it for some other, good priority reason. But one of the ways that there's been some fraudulent real estate transactions, a lot of it happens with abandoned property. Somebody's combing through and they find a house that no one's lived there, or a decedent, someone's deceased. And then they will literally claim that they own it and they sell it. And then all of a sudden you get a new tax bill and it's in somebody else's name. There's ways to protect against that. It's not too common in Massachusetts because Massachusetts, we're an attorney state, meaning attorneys handle closings, buying and selling. A lot of the states in the United States, they have title companies that handle closings. If any of you, I don't know about New Jersey, but do they use title companies? So title companies are a little different than conveyancing. I'm a conveyancing attorney. I've been doing closings forever. So it's a little bit different. Like we look at the titles literally online at the Registry of Deeds. Like I've been around so long. I used to go there and open the books and look at them. The title companies don't really do that. They rely on past titles. So I think that they're just like one step removed. So I think in Massachusetts, this is only my determination, because we use conveyancing attorneys, we're more focused on what's going on, and the fraud isn't as prevalent in Massachusetts. But, well, that's what I hear. I haven't thankfully had an experience like that. But, there's a lot of stuff happening now that I never thought would either. So, yes.
You may want to mention that the registry has a notification system about what you just mentioned.
Yes. So you can sign up with the Registry of Deeds. Bill O'Donnell, if anybody heard him when he came in, I do know that they've set up a notification system. You can go online or you can call them because they'll put you on it. And if your property gets sold or there's any information that's put on, a lien or something against your home, they'll send you an email message and let you know that the document was recorded. So unfortunately, it's still post, but at least, you get notification sooner than later. Okay. Thank you, Matt, for coming today.
Thank you. Yeah, thanks, Joanne, for having me again. I'm Matt Antonellis, for those that weren't here last year. So I am a partner at City Square Wealth Management in Charlestown. We're a franchise of Ameriprise Financial, really focusing on financial planning. Now, last year, when Joanne invited me, we talked a lot about retirement income, Social Security, a lot of the things that everybody in this room, frankly, is dealing with on some level on a day-to-day basis. And if anybody remembers last year, the questions and answering section kind of pivoted pretty specifically to selling your home, figuring out what to do with that, kind of next steps. We find, especially in Massachusetts, where the home values are as compelling as they are, it's a big, I wouldn't say issue, but it's an obstacle that you need to make sure you get right. And so I'm just going to spend a couple minutes talking through that, just some points to think about. A lot of it dovetails into what Joanne was talking about for estate planning purposes, but I think really spending most of the time opening it up, obviously, for questions after that. So just a real quick refresher on when you sell your home. When you do, you are able to exclude $250,000 per person. So in a married family, husband and wife, you can exclude $500,000 of appreciation if you've lived in your home 2 out of the last 5 years. So that's an important consideration, because if you go to sell your home, and that's probably, in a lot of cases, family's biggest asset, you want to make sure that you have a plan for, one, what you do with the proceeds, but also what are the ramifications of selling. And the biggest example is taxes. So a lot of people wonder, hey, what happens when I sell my house? What is actually going to be in my pocket to do something with? And we'll talk about that in a minute. But when you get to the point where you're selling, the calculation that's done by your accountant is, what did I sell for? What did I buy for? If I am below that threshold, I've essentially navigated without having to pay a tax bill on that. Now, there are ways around it if you are above that threshold. And what I mean by that is, let's just say, for an easy example, your house you purchased 30 years ago for $500,000. Right now it's worth $1.1 million. Okay? So you're above that $500,000 threshold by, say, $100,000. If you can show capital improvements to your home to that amount, that increases your basis. And what that means is it essentially erodes the amount above the exclusion so that you would not have to pay taxes on that overage. And that's a big number, right? Let's just say it's $100,000. We'll talk about the implications in a second, but that could be a $20, $30, even more $1,000 tax bill on just that $100,000. And if your objective is to take those proceeds, put it into another house, put it into a condo, downsize, you might need every penny to put into that next real estate investment. So the reason why it's so important to get that right is because there are a lot of ramifications on making sure that you have a good understanding of that. And the first is, again, capital gains tax. I'm sure a lot of people have heard of that term. It's basically the tax from what you bought to what you sold. It could be 15% federal, but if it's over a certain threshold, it could be even higher. So it could be 20% federal plus state taxes. Other implications, you could have net investment income tax. But I think what's more pertinent for this audience is it could have ramifications to Social Security. It could have ramifications to Medicare. So your Social Security taxation could be impacted by this. If you're used to not having much of a tax on your Social Security, if you don't have a sense for how much reportable income your home sale has, that could significantly increase how much your Social Security is taxed. That is capped at 85% of your total benefit. That's a big change. And the other piece is Medicare, believe it or not. So you could be subject to what's called IRMA, Income Related Monthly Adjustment Amount. I talked about a little bit about this last year, but if you go back 2 years in arrears, Medicare could actually significantly increase your Medicare premiums from, I think it's $185 for Part B right now, to hundreds of dollars more if they look at your income the year that you sold the house and it's significantly higher. And so it's not a small change. And so it's something that, one, you need to be aware of, and two, you need to try to plan for that with how you earmark some of the proceeds. So again, that's really kind of the consideration on the when you do go to sell. And obviously there's a lot of laws that protect most of your profit, which is wonderful. And then the question of what do we do with it, obviously, is predicated from everybody's situation, right? So Joanne mentioned everybody's going to have a different situation. You could be downsizing in Massachusetts. And unfortunately, again, going back to Mass, I mean, a condo in certain parts of Massachusetts might not even be much of a reduction in cost, frankly. So that's obviously something that, again, you're going to want to make sure you've got your ducks in a row on understanding how much of your proceeds are yours. But if you're going to go into, say, a rental, maybe you're going to go into a retirement community, what do we want to do with those proceeds so that they are working for you, generating passive income for you? So obviously, I think if I were to sample the room, if the question was, how do people feel about the stock market right now, I'd get a variety of different answers. And that's fair. And obviously that's a consideration, but the objective is those proceeds, in a lot of cases, especially for clients that we work with, they are generating your rental expense. They are generating your fees for your retirement community. So that is through passive income. It could be from dividends from stocks. It could be from interest from bonds. But figuring out, based on everybody's individual risk tolerance, what that split looks like so that you are essentially providing yourselves with that additional income stream that you might need now, right? Because you could have been in a home for 30, 40, 50 years. You haven't had a mortgage in a very long time. Now you might have additional expenses that if that money just sits in the bank, you're just watching it go down every month versus having it generate income and work for you. So obviously that's an important consideration, and the clients that we work with, it's a very real situation and scenario that needs to be worked through. Again, understanding what your money is actually going to land in your pocket and then what to do with it to allow you to continue to live your next phase of life, whatever that looks like, because it's going to be different, and that's okay. So that's obviously what we want to make sure we focus on. That is really kind of the very quick touch point. Again, I want to spend, Joanne and I talked about it last time, most of the time just opening it up for any questions that we have on that. Again, it was a very important topic to talk about, so happy to pause there and answer any questions. Sure.
Like a parent sold a child the house for $100. Now the house is worth, let's say, 700,000. I'm confused of where that,
So that scenario is a little, we need more information on that, because you have to sell it to a point where it's not looked at as like given away. So you get a fair market value that's assessed. But if you inherit a house, that scenario is a good point. And we can talk about more specifics. You get what's called a step up in basis. So what that means is, let's just say your parents bought it for 100 grand, and when they pass, it's worth 700 grand. You then, if you wanted to sell that house, would be stepped up to their date of death value when that appraisal occurs. And that's important because you're not assessed the tax on the $600,000 between what your parents bought and then when they passed. It's stepped up to their date of death, so that you would not incur any material taxes if you sold shortly after that. Does that answer your question?
it's kind of like, it's not even that their death. It was like, my father bought a house, we were living with him, and then he sold the house, let's say, for $100 to me.
Yep.
back
Right, so
30 years ago.
that's what Matt is talking about. You got your dad's basis. Had you waited until your dad's death to inherit it, you would get that step up.
But I inherited it before
He gifted it to you during his lifetime. That's the difference. If you gift it during your lifetime, whoever you gift it to, and a gift means you're not getting fair market value back, right? You're giving it to them for $1, for $100. They get the same basis that you do. But when somebody dies, there's what's called a step up in basis under the IRS code. And now that's the value of what they're getting. So when they sell it, there's no capital gains tax. You know, there's all kinds of taxes that we have to talk about. So that's some of the questions that I get from my clients as well. Should I add my child to my deed so we can do the rights of survivorship so that they can get it immediately when I die? Well, if you gift them 1/2 the value, then they're going to miss out on that step up when you die, which is another reason to use a trust. Because if you get it in the trust and I still own 100% of that house during my lifetime, then you get the step up in basis, but it's in a trust, so we don't have to go through probate.
You know,
I love you guys are getting all this.
Yeah, and I'll just add, because it's topical. So that step up actually also applies to other types of investments, and I think this is
absolutely.
also pertinent. So let's just say somebody bought, I've heard this story a million times, Apple in the early days for a few bucks a share. Now it's worth a whole lot more than that. So there's a lot of questions you get around, hey, I've got this amount of money that is very highly appreciated. And then there's other things that, you know, Joanne and I could weigh in on, you know, gifting strategies and, you know, things like that. But as far as, you know, the strategy when you don't need necessarily those dollars, the advice is typically try to wait to get that step up, because otherwise you're paying a considerable tax if you receive those while the donor is still alive. So that could be an investment portfolio. There's other rules for retirement accounts that I talked about last time, but you know, similar logic on the home versus like a portfolio. What other questions?
So if you have money in like a 401k diversified account thing, it should be under a beneficiary as well?
Always. That's a plug for Joanne, but it's always, you always want to have a beneficiary for the accounts. And the reason why, and I'll just spend a minute talking about this. So retirement accounts have different rules. If you have a beneficiary, that beneficiary receives the money in a qualified account and has to distribute that account in its entirety within 10 years of receiving it. And there's some nuances to the rule, and it depends on how old the beneficiary was when they passed. So it's less of a blanket statement, but the rules have changed over the last few years that you have to set that beneficiary up so that that beneficiary receives those assets because the IRS wants to get their cut. That money's never been taxed if it's in a pre-tax 401k.
Matt, can you explain the difference between qualified and non-qualified? Because I think that'll help.
Sure.
Thank you.
So qualified is retirement specific. So think of a pension, a 401k, an IRA, a Roth, government plans like a smart 457 plan. All are tax deferred. What that means is when you put the money in, you get a tax break, typically, at least on the pre-tax side. So if you make $100,000, you put $20,000 into a 401k, you only pay taxes on $80,000 that year. So that's a nice tax break. The money grows tax free, or tax deferred is a better term, until you take it out. And in the example that you're talking about, you then pay taxes on the way out. Now, non-qualified is money outside of a retirement vehicle. So think of that as like a brokerage account. Now, money that's outside of a brokerage account is less favorably treated tax-wise. So that could be money that you got paid a bonus, you got paid something, you invest it, year over year, you have to report that income that's generated. That you get like a 1099 that you give to your tax person. And then on the way out, let's just say, again, same example with the Apple. You bought the stock very, very early. You sell it down the road, you owe capital gains, similar to that home example. So the taxation piece is pretty different, and that's where my team and I get involved on. If you've got exposure to retirement and non-retirement, or qualified and non-qualified, what's the right bucket to pull from based on where your tax situation sits? Does that help kind of clarify the difference? What else? Any other questions?
If you have a unit and the beneficiary is under 18, they can't touch it till they're...
Usually that would be a successor or a custodian that would basically steward the account until they got to the age of maturity. What else?
I'll add something about the beneficiaries on an IRA, which is the qualified money, which has been accruing interest, dividends, whatever it might be, and no one has had to pay income on it. I have a decedent right now that unfortunately did a really good job to make sure everything had beneficiaries. All of our assets had somewhere to go except for one IRA. So what happened is that IRA, the beneficiary is now her estate. And because it's not a person in being, it's going to be taxed at a significant amount of money. So again, that yearly around tax season, make sure all of your beneficiaries are named and that you still like those people getting that beneficial interest. But then also that they're all updated. And if anyone is under the age of 18 or incapacitated, that's another reason to make sure that you're updating as well. Okay?
Yeah, and
So if you have beneficiaries, okay, and I have the question. If you have beneficiaries, and, okay, so you have the beneficiaries, because we do, and everything, but, you know, maybe one account was forgotten, like you said, this lady, but if in your will you say that everything is being distributed equally, are you covered that way?
Yes. So very good question. She's referring to having an account that doesn't have a named beneficiary. So where do we land? We land in probate court, right? Because it's an individual asset. And then that individual asset, we look to the direction of your will or your trust to find out where it's going to go. If those estate planning documents are not in existence, then it goes by way of the laws of intestacy. Okay? Which means your heirs at law. Somebody, the most immediate person to you, your spouse. Is this your spouse? So he would get it. I'm going to get his chair. If your spouse isn't there, then it goes to your children. If your children aren't there, then it goes up to your parents. and then out to your siblings. So there's a methodology to the heirs at law. And if you have a sibling that you want to make sure that they don't inherit something, all the more reason to make sure all of your beneficiaries are up to date.
By the way, Joanne and I know this is riveting stuff, so we totally get it.
I think it's a cookie that put him to sleep. You want some coffee?
Qualified and non-qualified, and you said which one to pull from. Which one do you
Any
pull
other
from?
questions? I know sometimes, we talk about this stuff and it can be confusing, but sometimes even just a little bit of a question's helpful.
Joanne, we have one right here.
Oh, okay. I'm going to go to this one first. I saw this one first.
Oh, sure.
I just have a question in terms of beneficiaries. I'm single, so my beneficiaries would be my siblings. So what happens, say I don't really like one of my sister-in-laws, and if my brother should die before her, does she have rights to his?
That's a great question.
That's per stirpes, right, Joanne?
Well, no, actually, because per stirpes is for your children.
Right, gotcha.
Yep, not spouses. So usually people arrange things to go through your bloodline, right? It goes to your children or your grandchildren, not your in-law, daughter-in-law, or your son-in-law. For your particular situation, your sister-in-law has no rights in what your brother would get unless you write that down as a beneficial, write her down as a beneficial interest.
Put that in as surviving siblings versus.
You can do it either way. So someone like Matt, I know he has all of his clients make sure that they fill out their beneficial certificate or beneficial interest correctly. I do find that there's different ways that you can do it, and people sometimes don't understand it. And then there's a death, and we have to kind of figure it out. But you can leave, how many siblings do you have? 4. So 4 siblings. So hypothetical A is you leave everything to 4 siblings or the survivors. So if only 3 survive, then 3 get it. Or you can leave it that the one that's deceased, it drops down to their children, okay? It goes down to their descendants. But that's particular, right? You have to make sure you either check that box or make sure that your financial advisor knows that that's what you want to happen. Because it doesn't happen on its own.
Exactly. So there's a free form on our side that you literally spell out exactly how you want it to go, because there are instances like that in families.
Yeah.
I'm just going to answer.
Yep.
Go back to this question here. Do you want to repeat that?
Okay. You talked about qualified, non-qualified, and which one to pull from first.
Yeah. So the question was, we mentioned the qualified or the retirement assets and the non-qualified or the non-retirement assets. And the answer, unfortunately, it's not as straightforward as one or the other. It depends on your situation. So if you are, let's just say, your pension and your Social Security, that by itself puts you right up against a tax bracket. If you have the ability to take from a non-retirement account that you don't have to pay additional taxes on, that would be the solution in that scenario. If you, the reason why is every dollar that comes out of a pre-tax retirement asset is taxed. So that could be something that, without you even knowing it, puts you into the next tax bracket. It would be less advantageous for you to pull from that. So it really depends on kind of forecasting where your income is based on where you are, but it's not as straightforward as one or the other. Does that make sense?
Right here, Matt.
I have a question.
Sure.
On certificate of deposits, do I have to worry about beneficiary?
Yeah.
Really?
Yeah, I mean,
Well, what's the name on the certificate on the CD? And what happens when you die? Where's it going to go? Does it go to your savings account? No. So it goes contractually. The product is a certificate of deposit, and it goes contractually to whoever you name as the beneficiary. If you don't name a beneficiary, it goes to your estate, and then it has to go through probate. Always think, does it have somewhere to go? It's the best way to think about the assets. Can it go to somebody else when I die? Does it go immediately? If it doesn't go immediately, then it has to go through probate.
What happens if you put 2 names on that CD?
2 ownership or 2 beneficiaries. So the 2 owners are joint. When my first owner dies, then what do we have? A probate asset. No. When my first owner dies, we have a probate asset. That's why people will say, oh, I own my house with my husband. I'm like, that's great until he dies. And then you have a probate asset. Okay, we're going to wrap up. Any other questions here? Oh, how do I get there from there?
I can take it.
Important it is to
Matt,
put someone's, well, you own the safe deposit box, but it's very important to put someone else's name on that
What?
to get
Shh.
in.
One
In case
second, there's one more
someone
question.
dies, there's no other name on a safe deposit box.
The comment was to make sure that there's another name on a safe deposit box in the event that somebody passes.
I love that comment. Thank you so much. Because that's an asset. It's an ownership interest in something, and if only your name is on it, that person has to go to probate court to get what? The authority to get into it. Okay?
But I went to put my son on our box. He doesn't live in Massachusetts, so they wouldn't let me put it on.
That's because we have Massachusetts banking laws.
So then if I die, they can't get
You can put me on it. You want to put me on it? What's in it?
There's nothing. I did away with it.
All right. Well, thank you very much for coming today. I appreciate it.